SJC-12080, Timothy P. Chambers and another, v. RDI Logistics and another.
Thank you.
Mr. Lichten, good morning.
Good morning. May it please the court, I'm Harold Lichten. I represent the plaintiffs in this case. Although there are 6 important issues in this case, there are 4 that I'd like to address before you.
Can we try and eliminate one right off the bat? Do you say that prong 2 of the Wage Act, do you agree based on the cases that you've submitted that there's preemption as it relates to the Federal Aviation Administration Act?
The answer is I don't agree with the decision. I'm not planning to argue it here, but there are other circuits that have found exactly the opposite, so I'm not waiving the argument, but I don't plan to spend any time arguing it here. And I recognize that you might follow the First Circuit. So the first issue is the FAA issue, and I think it's clear that the court erred because it did not have the benefit of about 6 decisions that have come down since he issued his decision, and all of those decisions make clear, both in the federal, state courts, and other courts around the United States, that while prong 2 could be preempted, prongs 1 and 3, which are traditional tests for employment found in most wage statutes, are clearly not preempted, and I think that's really a closed issue now in light of the very recent decisions that we've cited to you, and I'll get back to that.
It's a closed issue for us?
Yes, I think.
Meaning that you would say it's closed in the sense that prongs, I'm going to call them A and C, are available.
Exactly.
So that you're saying that with regard to employers who are within the scope of the FAA, a person is an employee if they satisfy, or if they satisfy both
One or the other.
1 and 3.
Okay. It's actually if the employer
or.
cannot satisfy 1 and
They
3,
cannot
but yes.
satisfy 1 and 3. They would have to satisfy both 1 and 3.
Not both 1 and 3. The employer,
Has
the
to-
person would be an employee if the employer can't satisfy 1 or 3.
Right.
Secondly, I want to address the fact that the court clearly erred in finding, based upon overwhelming and undisputed evidence in the record, that these drivers were not employees, or that there was a question of fact as to whether these workers were employees under prongs 1 and 3, when the evidence was overwhelming that they were, particularly the fact that there was a non-compete clause in their contract which prohibited them from doing any delivery work for anyone else, and there was a provision in the company's manual that prohibited them from having any products on their trucks for the 5 or 6 years that they worked full-time for this company.
Don't you also have to deal with the, because you're saying it was error not to enter summary judgment in your favor.
Correct.
But wouldn't the judge also have to determine something about the legitimacy of the corporate form?
That was the third thing I was going to get to, Your Honor. The court also erred, the court never addressed it, but it's clear from the myriad of cases both in Massachusetts and around the country that merely requiring someone to incorporate and then saying that they're not an employee because they were forced to incorporate does not absolve someone from liability under the Wage Act, and that's been the holding of 3 judges in Massachusetts. Judge O'Toole held that in HDA, Judge Woodlock held that in the Martins case, and Judge Murtaugh in the Townsend Oil case held the same thing.
But that's not the same thing as saying that when it's a legitimate corporate form, that there could be, what you've just articulated is that it's not enough, right? But, I mean, does that get you summary judgment?
No, in each of those cases, there was a legitimate corporate form and the people had incorporated
No,
with
I
the
meant that they might
secretaries.
have had a very good reason for wanting to do the corporate form, other than the impact of the agreement with the employer.
No, I disagree, Your Honor. Here you had workers, Mr. Chambers and Mr. Johnson, who worked full-time. They did incorporate their trucks. They did incorporate, but they worked full-time for 5 or 6 years, delivering product for them. The fact that they were incorporated is of no relevance in determining their status as employees under the statute, and that is exactly the holding of Justice O'Toole, Justice Woodlock,
Wasn't there
and
some
Justice
evidence
Murtaugh.
that one of them, and maybe it's Mr. Chambers, actually had other people working for him?
Well, all of these individuals, because they're delivering heavy furniture, are going to have to have a helper working with them. It would be literally impossible to do it on their own. But in all these cases that I mentioned to you, particularly Martins versus 3PD and Home Delivery America, the facts were the same. They were the same deliveries of furniture and appliances, and we've cited to you cases around the country, virtually every case around the country, including the MDL FedEx litigation, where the fact that someone had incorporated does not take them out of the ambit of the state's wage statute.
So it's not dispositive, but what are there, 37 independent contractors / employees that we're talking about?
I think they're more, Your Honor. I think they're more like 80.
Okay, so some of them may actually be independent contractors, and some of them might not be. You have to look at each one separately, don't you?
No, for the following reason. If we were dealing with prong 2, which I'm conceding is out of the case, where prong 2 would make anybody an employee, even if they were, as long as they were within the same business as the company they were working for, then it gets a closer question. But prongs 1 and 3 take care of that, because regardless of whether someone has a couple trucks or what they're doing, if they're controlled by RDI, if RDI
I
retains...
mean, like the logos, like the GPS in the trucks, those
Uniforms.
issues?
Yeah, RDI had a 25-page manual that told them everything to do, including
How
wearing...
about picking routes?
What?
How about picking routes to drive?
Same thing. You mean the RDI assigning routes?
Right.
Same thing.
I mean, the way you would get from somewhere to Jordan's Furniture or Jordan's Furniture to somebody's house?
Yes, yes.
That was assigned?
Yeah, yes, they gave these people strict time windows, and you showed up and you were given your route and you were given your orders and you had to do it. You had to show up at a specific time. There was a manual, a 25-page manual that's in the supplemental appendix that gave exquisite instructions as to when you had to show up, and you couldn't have, and in addition to that, under prong 3, if you couldn't do any other work, if you were prohibited from having any other product on your truck, as they were because they were driving under RDI's DOT number, that's proof positive that the persons could not have an independently established trade or business under prong 3, because an independent contractor, by its nature, is someone who can go out and perform other services for other people. So I could envision furniture delivery drivers.
To the outside world, this is a Jordan's Furniture truck.
Yes, they would not,
Going to have Bernie and Phil's furniture on a Jordan's truck.
they were not allowed to.
Right.
Because the manual said you can't have any product because you're driving under our DOT number. You can't have any other product on your truck. And there was a non-competition agreement. And that's the essence of not being an independent contractor, that you can't go out and deliver for anyone else now or for 3 years thereafter.
I'm now thoroughly confused because you're asking us to grant summary judgment, but how can you seek interlocutory appeal for the denial of summary judgment? I mean, I know that you can be here with regard to the judge's grant of summary judgment, but where a judge says, I deny you summary judgment, how do you get to this court to say the judge erred in granting summary judgment where that's a plainly interlocutory appeal? And it would seem to me that if you prevail here, the best you're going to do is go back to the Superior Court.
Well, that may be. What I was referring to is the court said in its opinion, it's only in one sentence, that if I were to reach the merits, I would find that there are disputes of material fact on these prongs, and I'm saying that was an error. There was a sufficient and overwhelming evidence to demonstrate that as a matter of law they were employees. If that's a reversal and a remand back to the judge, that's fine, but I think he was wrong in that statement. I don't want to...
But that's not before us right now. I mean, we can't give you summary judgment even if we think you are entitled to it.
Well,
I
that
guess
may
what I
be,
mean-
and let me move on. Okay. I did also want to address, as you already asked, Judge Lank, the incorporation defense. It's clear beyond doubt that if you allowed a situation to exist where you could get out of being an employee simply by incorporating, then as Judge Murtaugh says in Townsend Oil, you would just require everybody to incorporate, and then by special contract, which is illegal under Section 148, you would be absolving all these people who work full-time doing nothing else for the company from being an employee under the Act. And that would be, as Judge O'Toole said, that would be putting form over substance. And literally, this issue has come up in the workers' comp context, in the unemployment context, all over the country. And we've cited to you in a footnote many cases where the courts have rejected that, as well as the 3 judges here in Massachusetts.
But pragmatically, what does that mean if what you claim to be the employee himself or herself hires other employees? Are they all deemed to be employees of RDI even though they didn't hire them?
I'm not representing, and I have not brought a case on behalf of the helpers. Whether the helpers are employees of RDI is a question best left for another day because it's not before you. In addition to that, since the damages in this case relate to the deduction of money from their wages, RDI was deducting thousands of dollars from their wages. If you hurt the petunias in the house that you were delivering to, they would deduct hundreds of dollars from your wages. If you scratched a piece of furniture, even if it wasn't your fault, they would deduct hundreds of dollars. They didn't do that to the helpers. They did that to the people who signed the contracts with them. So you don't have the question of the helpers before them.
But what about the contractors who had their own vehicles and hired people to do the delivery and the pickup?
That's not before you either, because we had moved for class certification and we had moved for summary judgment as to the 2 named plaintiffs. That's the way the case went to the judge. The only question before the judge was whether these 2 plaintiffs were employees under the Massachusetts Wage Act. The question wasn't before the court with respect to everyone else in the class. That would have occurred, and we did argue that in class certification. And I argued, I think very persuasively, that given what the contracts
I
say...
do say so myself.
What? Yes. That given what the contract said about non-competition, you could decide this on a common basis. The fact that you have a helper doesn't mean you're not an employee. There are many cases in the FLSA from the federal courts to say the fact that you work on a farm and you have your son or daughter or your wife help you pick the crops doesn't mean you're not an employee.
So what's the problem with a company deciding that it wants a certain business model that involves independent contractors? The law says if they're independent contractors, they're not employees. So what's wrong with a company trying to develop a way to deal with independent contractors? I mean, this sounds like a response to the proliferation of litigation around who's an employee and who isn't.
Yeah.
So why can't he do that?
Yeah, so that's a great question. First of all, one of my clients, Mr. Chambers, worked as an employee driver for Jordan's Furniture until Jordan's contracted the work out to RDI. The next day after RDI took it over, my client, Mr. Chambers, was doing the same thing he did the day before. Many employers, many companies now are trying to create these independent contractor relationships to get around the wage laws, and it's been an epidemic in the federal and state governments.
If it's legal,
Well,
then
I'm gonna
why
get to
can't
that.
they do it?
Because the Massachusetts legislature, in their wisdom, has created a standard for determining that. Now, I'm assuming that you're going to knock out prong B, which is the most harsh provision for employers. It would make it almost impossible if you're in the business to have someone be deemed an employee. But prong 2, let's assume, is out for this case because of the F quad A. That leaves prong 1 and 3. Prong 1 and 3 are traditional tests for employment that almost every state in the country uses one form of that. The typical right to control, which is prong 1, is the standard you find in almost every state on common law for determining tort liability. Prong 3, which looks at whether you're an independently established trade or business, is the common standard under the FLSA and many other wage statutes called the economic reality test. That is, you look at, as a matter of economic reality, whether the person is in business for himself or whether they're economically dependent upon the company that they work for. So to answer your question, Justice Hines, the legislature has determined that there are legitimate independent contractor relationships, and with prong 2 gone, I could envision a situation where you have companies, they have their own website, they have their own business cards, they do lots of deliveries, and they look up on a bid board and say, okay, RDI has some deliveries for Jordan, we'll do that. Tomorrow, or that later, or that afternoon, we'll do deliveries for this company. But you can't do that with RDI. These guys work there 6 days a week, 5 or 6 days a week, for 6 years doing nothing but RDI, and they could not work for anyone else. So to answer your question, there certainly could be legitimate independent contractor relationships, and RDI could do that, but I don't think RDI could really run its business if they weren't sure that the independent contractor was going to show up every day as required and follow all of the myriad of rules that they had.
So considering all of this, and what about the severability issue? Because obviously there's a presumption in Massachusetts set up by the statute that somebody's an employee. And I appreciate your point that you could have, quote, independent contractors, end quote. But considering the intent in Massachusetts with the Wage Act, can prong 2 be severed?
Yes, there's no question that Massachusetts has a statute that says you should sever where possible. The First Circuit already ruled on this issue in Schwann and said that prongs 1 and 3 are severable. Their reasoning is exactly correct. But it's clear that you're supposed to, as justices, look at the legislative intent. And if you believe that the legislature would have been happier with having some prongs left instead of no prongs at all, then you must give effort to that intent and sever, and that's what the statute in Massachusetts says. It says you should sever whenever possible. If ever there was a statute that is severable, it's here, where you have 3 independent tests, any one of which requires a finding of employee status. I know my time is up, but I really wanted to address the question of the pernicious use of releases in this case.
I wanted to ask about that. They are correct, I gather, that they sent their letter before you had moved for class certification.
That's correct, Your Honor. But Rule 20...
What is your position? Did you represent these individuals at that time?
They were a putative class. The law is absolutely clear that under Rule 23D, a court has the obligation and authority to make orders and rulings to ensure the fair and efficient administration of a class action, and that's been interpreted both in the federal and state courts as meaning pre-certification. There has to be fairness too, to prevent abuse from both sides. And in the U.S. Supreme Court held in the Gulf Oil case that their obligation for a court to make sure that there's fairness with respect to both sides adheres even at the pre-certification stage. It's not so much whether I represented them or not. That's sort of an interesting esoteric question. The question is whether there was abuse going on in the way this was done. Now, there were 3 Superior Court decisions.
He abused his discretion? Is that your argument?
What?
Is the standard whether he abused his discretion?
The judge.
Yes, I think that's fair, although I think there's more here, because under Crocker, you've decided that because of the special contracts provision in the Wage Act, and given the fact that there is special protection required when someone has an ongoing relationship. I mean, these workers were subject to having all their work through RDI. Of course, they're going to be intimidated when RDI comes to them and says, you know, we want you to sign this release for a fraction of the amount that the case was worth.
Well, some didn't. Some went to the lawyers.
1 or 2 did, but even those wanted to remain anonymous and wouldn't let their names be used.
But didn't the release include the docket number and the name of the case?
Okay, so the courts that have addressed this in the Legal Seafood case, the Mendez case, and the Machado case, all from state Superior Court justices, which rely on the federal court, says there's a series of things you should look at. And here, there is the implication that you would have to pay your costs and attorney's fees if you lost, because they said we're countersuing the named plaintiffs for costs and attorney's fees. They did not even tell them what the claim was. It was for all these deductions that were taken from the pay. The letter itself, not the release, but the letter, doesn't even tell them the claim arises under the Wage Act. It doesn't tell them the amount they could recover. It doesn't tell them about that they could recover treble damages, that they could recover attorney's fees, and in 3 different places it says, of course, we value our relationship with you and we would never do anything wrong. We believe strongly we didn't do anything wrong. And courts that have reviewed this set of standards have said that that's not enough. To do it properly, it would have to be, there is this case, here's the complaint, here are the attorneys, this is what the complaint alleges. And if you look at the legal seafood case, which I think is a very well-written decision by Judge Wilson, there they gave far more information and were paying a much higher value for the case, 25% of the actual damages. He still issued an injunction against the releases. Here, people had thousands and thousands of dollars deducted from their checks, and they were offered $1,000 from a company that still had sway over whether they did business anymore.
Let me ask you, you talk about the standards for pre-certification behavior. Does there have to be knowledge that there is going to be a motion brought to certify a class?
Knowledge by whom?
Well, in this case, by the defendants.
Well, I don't think the defendants had any
Was
misapprehension.
it part of the, is it part of the complaint? Is it
Yes, of
drafted
course.
it's drafted as a putative class action?
Absolutely.
Okay, that's the question.
Yeah, they had no, they absolutely were aware. In fact, we had a mediation session with them prior to their doing this. The mediation session, this is in the record, broke down, and then they did this. And obviously, they knew it was a class, and those were what the discussions were with the class. So I really think this is an action that is all of a sudden being used by some law firms in the city of Boston and in Massachusetts, and if left unchallenged, could really do a lot of damage to the integrity of the class action process. And I think there is an obligation on this court to say that judges have to police this in a fair and equitable way.
And are you saying that it must be approved by a court before it's sent out, or simply that they must do it appropriately?
I believe that they take their risk. If they're going to do this, they take a risk. And if they don't do it fairly, giving all the information necessary for someone to make an intelligent and knowing waiver as you require under the Crocker case, then they act at their risk. And if they don't do it properly, then the court should intervene as we timely asked the court to intervene here. At the very least, there should have been discovery on this issue so we can find out exactly what happened, because today we still don't know. We had asked for discovery on this issue. The court granted it, but then when he granted summary judgment, the case was dismissed, so we never got to the bottom of how much contact there was, what they said, and what happened. We just know from what they've said that they've gotten a bunch of releases from a considerable number of people, most of whom still were dependent at the time on RDI for their livelihood, which is coercive.
Okay, thank you.
Thank you very much.
Mr. Grant, I'm afraid it's good afternoon now for you.
Good afternoon, Mr. Chief Justice, Associate Justices. My name is Michael Grant. With me is my colleague Andrew Fay, here on behalf of the defendant appellees, RDI Logistics and Richard Longchamps. Plaintiffs lack standing to assert claims under Section 148B because they purposefully elected to use the corporate form and secured its advantages.
Well, isn't that the question? I mean, why does that mean they don't have standing if they're challenging that?
Well, the way Section 148B is drafted is it says that you must be an individual in order to seek relief under the statute. And I want to be clear that our position is not that simply by electing to use the corporate form, the plaintiffs were thereby precluded from seeking relief under 148B. Rather, as you can see from the trial court's factual findings in its memorandum of decision, the record is...
Why would the judge have been in a position to make factual findings on a motion for summary judgment?
I'm sorry, Your Honor?
Why would a judge be in a position to make factual findings on a motion for summary judgment?
I mean, those are the undisputed facts? Is that what you mean?
Yes, and so I guess I would more accurately refer to the undisputed facts. And those were that the plaintiffs both chose to incorporate. One of them had a pre-existing business partner who he had been a partner with at a...
The plaintiffs brought this in their individual capacities, correct?
They did.
Yeah.
But we allege that they lack standing because in Massachusetts, the Attorney General's office and the legislature recognizes that there are legitimate business-to-business relationships.
Well, and the question is this one of them? One of them, and that's the question that has not been resolved, right?
Correct, and as we said in our brief, although the trial court did not make any conclusions of law on that issue, the record is sufficient for this court to make an independent determination that summary judgment in defendant's favor was valid for that independent reason, aside from the preemption issue.
But just, if I am understanding your argument correctly, let's assume, I know this is not your position on these facts, but let's just assume that this is all, that these corporations are completely shams. I mean, that it's really violative of the Wage Act. Just assuming hypothetically. So the plaintiffs individually come into court and say, you know, we were forced to do this. We really are employees. You're saying they don't have standing to say that?
No, if that's the claim that plaintiffs are actually asserting, that's fine.
Is that the claim they're making?
No, I would say they didn't make that claim, and there was no evidence to support such a claim on summary judgment, because defendants couldn't avoid the fact that throughout the relationship they filed corporate tax returns for their entities in which they took tens of thousands of dollars of business expense deductions, including expenses for the employees that they hired and fired, which was dozens over the course of their relationship.
I'm sorry, I don't think that's the question. Separate and distinct from this case, just because somebody has a corporate form, if they're really an individual and they're really an employee, and it's violative of the Wage Act, the fact that they incorporate it doesn't mean that they don't have standing. That's just a circle.
Correct, and that's not at all what we're arguing. And this case was on summary judgment. And my brother said that points to case law that it's undisputed that you can't use the existence of a corporate form to say somebody can't pursue a Section 148B claim. Right. Judge O'Toole did make that finding in one case. However, he found in a different case that for that exact reason, the plaintiffs couldn't pursue a Section 148B claim because they filed corporate tax returns, they hired and fired employees, they ran multiple trucks with multiple routes. Here, one of the plaintiffs that had a business partner did run multiple trucks and multiple routes.
But the judge here didn't rule for you on that ground, correct?
That's correct, but
So
under
you're saying that you should win on a ground that the judge did not reach.
That is an alternative argument, and under Fredette v. Simpson, I think the court can reach that conclusion.
Okay, but meaning you don't wish to argue that you should prevail on the ground that the judge did reach? Or you just haven't gotten there yet?
Just haven't gotten there,
Okay,
and I will
maybe you should go there.
take that signal and move in that direction.
I think that's probably a correct reading of the court, or at least of me. So, okay, so let's focus on what the judge did find, and he found that it was preemption as to all prongs, determined based on summary judgment, correct? Was no was held. So, is it your view that there's preemption on all three? Or is your view that, what is your view? What happens if there is preemption? Does it mean that that the common law rules apply, or that no rules apply?
That the common law rules apply. And the analysis, and I think the way the First Circuit looked at this issue in Tobin is the correct way to look at it. And they said it's not whether a putative employer can possibly satisfy each and every prong of the ABC test. Rather, it is what is the outcome of the claim. In other words, the application of the law in the context of the claim that the putative employee is asserting that dictates whether it comes within the scope of preemption under the federal law. And so here, whether you apply, whether the plaintiffs prevailed in defeating us on the first prong, the second prong, or the third prong, the outcome is the same, and that is that it would compel RDI to change its business model from an independent contractor-based model to an employee-based model. And that is precisely the sort of prohibited effect that Congress talked about when it enacted the F-Quad-A in 1994.
Okay, but so you're saying, as I understand it, that we should find that the FAAA preempts 148B, but that it does not preempt the common law definition of what independent contractor is, meaning that the common law is okay and not preempted by the FAAA.
That is correct, and it preempts it as applied to motor carriers or freight forwarders or brokers.
And if we were to, and I didn't go back to look to see what the common law says as to how we define independent contractors, but how different is it from prongs 1 and 3?
Well, it's very interesting because the plaintiffs talked about that point and said, well, prong 1's very similar to some aspects of the common law, and prong 3 is very similar to some of the tests under the Fair Labor Standards Act, which is an economic realities test, which is similar to the test that the IRS uses. And so the law that would apply in the wake of this is the common law test, which includes more than just the first prong and more than just the third prong. In fact, under the IRS test, there are 20 factors that apply to determine.
But
And
let's say that the common law test winds up with these people not being regarded as independent contractors, but as employees. Doesn't that then also compel your client to change its business model? And why then wouldn't that be preempted?
That's what he's saying it is.
It wouldn't be preempted if it was consistent with the federal test, which would be the FLSA or the IRS test, and that is because Congress had two goals in enacting the preemption provision of the F-Quad A: to prevent states from undoing the purposeful deregulation of the trucking industry, and two, to avoid having interstate motor carriers such as RDI have to comply with a patchwork of state laws. But if the Massachusetts law is the same as the federal law, then we're not running afoul of Congress's goal of not having to comply with one law when you're in Massachusetts, but when your guy crosses over into New Hampshire, having to comply with a different law, and then when he gets to Maine, he has to comply with a different law there.
Okay, but my question was, if the result is that, that they're employees and not independent contractors under that test, doesn't that affect your business model?
Yes, but it wouldn't be.
And so that's okay.
Yes, if under the FLSA, and if the common law tests were the same, the plaintiffs were found to be employees, not independent contractors, then yes, that would affect the business model, but Congress hasn't prohibited that from happening.
The First Circuit case that, is it Schwann? I'm not sure what.
Yes.
Is that right? That's the one that says, yeah, prong B is out, but A and C are still alive and kicking? Is that right?
Well, I would disagree with that, Your Honor.
But I mean, is that, I can't remember now. I hadn't heard the expression F-Quad A. I like that. Is that an F-Quad A case?
It is.
Okay.
And FedEx was the defendant in that case. So not entirely the same here. The services couldn't be performed by a...
It's an F-Quad, they're interpreting the F-Quad A.
It is. And what the First Circuit expressly found when you read that opinion is that FedEx had conceded at the trial court level that it was not seeking a determination that prongs 1 and 3 were severable. And then on argument, and this is in the Schwann opinion, and said that FedEx does not argue otherwise, counter to plaintiffs saying that even if prong 2 is preempted, 1 and 3 is not. And then the First Circuit says, for that reason alone, we determine that prong B is preempted. It then went on, and I would submit this as dicta, and said, we opine, if the legislature were confronted with this question, then it would prefer 2/3 of a loaf, being prongs 1 and 3, as opposed to no loaf at all.
Did it go back down?
It did.
And what happened down below?
Yes, it's pending. I think there's summary judgment briefing going on right now.
What about the Mass Delivery Association case? What happened with that with preemption?
The First Circuit likewise held that prong 2 is preempted, but that was the only question before it. The MDA, in filing that action for declaratory relief, sought only a judgment that prong 2 is preempted. Going back to the First Circuit's dicta in Schwann, the interesting thing is it said what the legislature would prefer. In fact, if you look at what the legislature has done in the past decade with respect to Section 148B, it has considered and rejected 11 bills that would make the statute disjunctive in the exact manner that plaintiffs are proposing here. In other words, you could use 1 and 3, and if you failed to satisfy. So on 11 occasions in the last decade, the legislature has refused to revise the statute in the exact manner that plaintiffs are requesting the court to do here.
But
Okay.
not faced with preemption as an alternative. You're saying that this subsequent legislative history, if that's to be considered at all, is to be considered in a vacuum, I mean, because you could also look at that and say the legislature did that because they didn't want to weaken the tests.
Right. In other words, it's not a severability issue that the legislature is looking at when they're deciding whether or not to adopt legislation. That's not the same analysis because they didn't adopt 11 bills. It's what would happen if they had no choice but to exclude prong 2, would they keep prong 1 and 3?
Right, and the standard, as I read the case law, is in order for this court to make that determination, it would have to know, based on something, that that's what the legislature would have preferred to do as opposed to nothing at all. But here, I don't think there's anything in the record. The only thing in the record about what the legislature would prefer to do is what we submitted in terms of the post-legislative history.
Well, which way does that cut? 11 times they said no. Maybe they really want to have a presumption of employment here.
Oh, there's no doubt. There's no doubt that they do. But that means that you can't just assume that the legislature would say, okay, when they purposefully use the word and 11 times decided not to substitute that with the word or, making it disjunctive. It is a conjunctive statute, and those prongs are inseparably intertwined.
Okay, sorry, go ahead. Finish up, I'm sorry, I didn't mean to interrupt.
A more fundamental point is the court need not even reach the severability issue because as under Tobin and really under the Supreme Court authority that we rely on, that being the Roe case, the Morales case, the preemption analysis focuses on the outcome of the claim, not whether a defendant can possibly satisfy it in any perfect universe.
But I'm afraid that I'm confused by what you're asking us to do. I had thought you had said that if the common law rule applied to govern who is an independent contractor, that would not be preempted by the F qua A. Is that correct?
Correct. So long as it was consistent with federal law.
And is it?
The FLSA.
Yes.
Okay, so that would be okay. And 1 and 3, would that be, in your view, preempted by the F qua A?
Well, the entire claim would be preempted because prong 1 in and of itself is not consistent with the FLSA, and prong 3 is not in and of itself consistent with the FLSA. So, but I don't think the court even needs to go there. All it needs to decide is whether the outcome of applying Section 148B to RDI in this case, through any of the 3 prongs, would compel RDI to convert its business model.
Okay, but it seems as if the issue, and with regard to preemption, is whether or not we think that the legislature would have preferred to go, if 2 is gone, to proceed with 1 and 3, or whether the legislature would have proceeded to have 148B essentially be read. An individual performing any service shall be considered to be an employee under those chapters unless the common law determines that the person is an independent contractor. Is that what you say? Is that how you think we should now read it?
I believe the latter way, Your Honor, just phrased.
So we should basically say the legislature would have wished us to incorporate the common law into the definition of an independent contractor under 148B.
I don't think so. I think the legislature would say we have the common law, so you don't need to even deal with Section 148B because under any circumstance, it is preempted by federal law.
Well, but there are penalties for the failure to comply with 148B, and are you saying that there would be no penalty under 148B for any motor carrier?
That's correct, but
even if the common law determined, even if the people were employees under the common law.
Right, then you would just go directly to the statute, whether it's 148, whether it's 62B, whether it's 151 or 152 for workers' compensation. You could go straight to the law without having to utilize Section 148B and by extension Section 150, which says you get treble damages and attorney's
So
fees.
you basically say that now independent contracting should be determined with regard to your business by the common law. And did the judge make any determination as to whether or not there were no disputed issues of fact as to whether or not under the common law they were independent contractors? I don't recall him addressing that issue.
No, and I don't think he would have because the plaintiffs didn't assert that claim. Their only claim concerning misclassification was 148B.
But you're saying 148B should now incorporate the common law as its definition of independent contractor.
No. My argument is that the common law exists independent of Section 148B, and because of the federal preemption law, Section 148B cannot be applied.
Okay, so even if you were to violate the common law, there's no sanction?
No, if you violate the common law or the FLSA, there are plenty of
Is
sanctions.
there any sanction under 148B?
It would not be the sanction under 148B.
And the common law you're referring to there is not necessarily our common law. It's only our common law if it's consistent with the FLSA, right?
Exactly.
That's what you're saying.
Yes.
So before, I know your time is up, but I still have a question with regard to the retaliation claim. Is it your view that where there is a dispute as to whether somebody is an employee or independent contractor, it is not a violation of our statute for an employer to say, if you were to join in that action, I will fire you?
Section 148A uses the term employee multiple times, whereas Section 148B uses the term individual. And so our argument to the trial court was that Mr. Chambers' retaliation claim failed because it was predicated on a preempted definition of employee. It was not directly preempted by federal law, but rather he said, because I am an employee under 148B, I can assert a retaliation claim under 148A, which limits its application expressly to employees. And here again, the FLSA has a retaliation provision. So if Mr. Chambers were able to demonstrate that he was misclassified as an independent contractor under the FLSA, he would have standing to pursue a retaliation claim under the FLSA.
But he would have no standing under our state statute to invoke that claim.
Not unless he establishes that he's an employee, because that's the term that the legislature used.
So basically, it's you can do that unless he wins. If he were to prevail and say, I am an employee, then you would have sanctions for retaliation.
If he proved that he was retaliated against, yes.
Well, he could at least bring the claim.
Yes. Correct. And I see my time is up. If the court has any questions on the issue of settlement communications, I'd be happy to answer them. Otherwise, I'll rely on my briefs.
Okay, thank you.
Thank you.
All right.